Hi, my name's Isaac Shutt. I'm an estate planning attorney. I'm licensed to practice law both in Texas and in Wyoming. And in this video, I'll answer a question that we get all the time, and that is, how do I prevent a beneficiary from contesting my last will and testament? Well, let's dive right into it. There's two really important things that you should do. Number one, you should have an attorney prepare your last will and testament instead of doing a DIY or online type of thing. Number two, you should make sure that that last will and testament contains a no contest clause. So let me expand on both of those things. So first, I said you should make sure to have an attorney prepare your last will and testament. And you would say, of course, Isaac, you're an attorney who writes wills for a living. So of course you're going to say, I should have a last will and testament done by an attorney. Well, yeah, you should definitely have your last will and testament done by an attorney, but especially if you think that there's an enhanced likelihood that your will be contested. So, for example, a lot of times we have, let's say it's a son and a daughter who are left 50-50 beneficiaries, and you just know that your daughter feels like she's entitled to more than her half. Well, that's an enhanced likelihood of a contest, so this is where you should be especially careful. So the reason you should have an attorney is, yeah, that attorney is going to make sure that all the T's are crossed and all the I's are dotted and things like that. But also just the fact that an attorney prepared that last will and testament is really good insurance against a will contest. Let me explain why. See, when you have an estate planning attorney prepare the last will and testament, a will contest attorney automatically knows that a lot of his ways of poking holes in the will aren't going to work. I mean, when somebody comes into my office and says, Isaac, I'd like you to contest this last will and testament, can I hire you to contest this last will and testament? The first thing I do is look to see if that will was prepared by an attorney or not. And if it was, I'm already thinking it's probably not a client I want. And if I see that it was done by, one of the online providers, I go, well, maybe this is a decent case. And the reason I think that is, if I know that that last will and testament was prepared by an attorney, I know that that attorney understands, a will can't be forged. I need to make sure that I'm dealing with the correct identity here. I need to make sure that this client is of sound mind and knows what he or she is doing and is not being unduly influenced by anyone. So just by the mere fact that an attorney has prepared your will, it's going to make it harder for somebody to hire an attorney to contest your will, because any attorney that's looking at that will is going to go, shucks, I'm not going to contest this will because it was done by a lawyer. I'm going to move on to the next case. So I know that seems kind of silly, but I mean, that's reality. And I'll give you another example. I've had a will of mine contested before in court, and the family came back to me and said, hey, Isaac, I want you to defend against this will contest. And so the other side, who was suing to dispute the validity of that will, said, wait, time out, Judge. This attorney cannot represent the family in defending the will because he wrote the will, so he's a fact witness in this will case. And the judge was brilliant. The judge said, well, wait a minute. Before we're going to say that Mr. Shutt is disqualified as the attorney to defend this will because you think he needs to be called as a witness, let's get from you an example of the type of question you would ask Mr. Shutt about the validity of this will. And the other side, who's trying to dispute the will, could not come up with an answer. They could not think of a single question that they would want to ask me to invalidate that will in a courtroom. And the reason is simple. The judge knew that if they ever called me as a witness in a courtroom, I would destroy their case because I've done thousands of wills, and so you don't want me on the stand if you're going to try to dispute a will, because I know the law. I know what goes into a valid will, and my will is going to hold up. So I am going to do my dead level best to be a good witness to make sure that that will holds up. So again, just if you're thinking that there might be a will contest, get an attorney, because that attorney is going to make sure that the will is done right and it's ironclad, and it's going to make it harder if somebody tries to contest that will to have a good, successful trial, because that attorney who prepared the will could be a witness that would be a great witness for you on the stand. So that's number one, have an attorney prepare the will. Now, number two, make sure that that will has a no contest clause. And in the law, it's actually called an interim clause. An interim clause is basically says if anybody who's listed as a beneficiary in this will tries to contest the will, and it gets a little bit more specific than that, like if they, allege that I was unduly influenced or lacked soundness of mind or whatever. If they challenge the will on any one of those things, then they don't get anything from my will. And the reason that no contest clause works so well is it really puts some skin in the game by that contestant. So if you think of it another way, if I'm that 50-50 situation and I'm that daughter who feels entitled to 80% of the estate instead of 50% of the estate, if I feel like I've got nothing to lose by contesting the will and alleging that I'm entitled to more, well then why not give it a shot if I'm not giving up anything? I mean, maybe I'm giving up a little bit of attorney's fees, but they'll probably settle and I'll probably get something more than 50%, so it's worth a shot. But it changes if there's a no contest clause, because now if that 50% beneficiary tries to challenge the will and loses, then you get a goose egg, you get nothing. So you've got a real problem there. So if you put that no contest clause in there that states if anybody who's a beneficiary challenges your will, they get nothing, that is really good insurance. So there you are. There's the whole video. If you want a will that is less easy to dispute in court, A, get a will done by a lawyer, and B, make sure it has a no contest clause. I hope you found this video helpful. If we can be of further assistance to you, our information is down below. My name's Isaac Shutt. I'm an estate planning and probate attorney licensed to practice law both in Texas and in Wyoming.